Good afternoon, everybody. My name is Thomas Deisenhofer. I'm Principal Advisor for ex post economic evaluation here in DG Competition. And very warm welcome to all speakers and participants at this DG Competition online workshop on our recently published study on the implementation and effectiveness of antitrust remedies. So you can see this is the study, and this is the study which we're going to discuss today. Now, program of today's workshop is straightforward. You can find it on our website, and we have a great lineup of speakers. In the first part of the workshop, the authors of the study will present the main findings and the recommendations made in the study. We will have Francesco Sciaudone from Grimaldi Alliance, Nicola Tosini from NERA, and monitoring trustee Thomas Höhn. The second part of the workshop today will be chaired by Damien Girard from the Belgian Competition Authority, and he will chair a panel with three experts: Vanessa Turner from BÖK, the European Consumer Association, monitoring trustee Justin Menses, and Bernd Meiring from Linklaters. Now, before we go into before I make some introductory remarks about the study itself and the background, a few housekeeping points. First of all, you can find the program of the workshop, plus a link to the study and a link to a fact sheet, which is useful if you want to find back some of the facts that are going to be discussed on the website dedicated to this workshop. Secondly, I would ask participants that are not speakers, if possible, to mute their camera. This will help also with the bandwidth that is used for the conference. Thirdly, the participants, so we have decided to run an open chat, so all participants can ask questions via the chat. Damien and I will try to collect those questions and put at least some of them to the experts and the authors. We've decided to leave the chat completely open, but please remain respectful, constructive in the chat, and if possible, don't start a parallel discussion there. For the speakers themselves, we discussed it already. Please unmute yourself to speak and mute yourself again once you have spoken. Now, before handing the floor to the author of the study, let me say a few words about the background of the study and its objective. The decision to do this study was taken in 2022. And the reason why we took that decision at DG Competition was twofold. One, it's part of a broader effort to invest in ex post economic evaluation and to strengthen, if you want, the evidentiary basis for policymaking at DG Competition. So we invested, for example, last year in a report on protecting competition in a changing world, which is part of this same set of efforts. The second reason was that we were anticipating the 20 years of Regulation 1 and the evaluation of Regulation 1, and we said it would be important to bring also a study on this crucial topic of antitrust remedies. The study was then conceived by a team composed both of the principal advisor on post-economic evaluation, myself, and representatives of the antitrust network. And there were four important members here: Anna Vernet, at that time head of unit in pharma, now member of the cabinet of EVP Ribeira; Sean Mernack, also now member of the cabinet of EVP Ribeira; Luca Manigrassi, and Alex Papanicolaou from the antitrust units. They were, throughout this whole 2 years, part of the design team, of the tender team, and of the team accompanying the study. And I want to use this opportunity to thank them very much for all the great contributions they've made. The inspiration for the study was the 2005 merger remedy study, which at the time had a major impact on our remedies practice in the field of mergers, leading to the 2008 remedies guidelines. But we could this time not, one of the lessons we learned from the merger remedy study is that we cannot do such a huge study internally. At the time, 10 case handlers did more than 145 interviews over 3 years. We don't have the resources to do such a huge effort internally. So in October 22, we tendered the study. In May 23, it was awarded to a consortium led by Grimaldi, Nera, with the implication of Tom Höhn and Professor Whelan. And since then, there were bi-weekly meetings, various interim reports on which the internal DG Comp team commented, and the delivery finally November 24 of the final report. An important note on the setup is that the contractors worked in close cooperation with DG Competition, but importantly, they worked independently. And this means that the study is the contractor's own work and does not bind DG Competition. That's an important point to make right at the beginning. We believe nonetheless that it brings important new evidence and insights and policy recommendations to the debate on the future of Regulation 1. On the objective, just 3 words. One is that the objective is limited to the effectiveness of antitrust remedies. So, like the merger remedy study in 2005, the study does not question whether perhaps antitrust decisions should have pursued different objectives. It only questions whether the remedies were effective to achieve the objectives set out in the decision. A second point is that the objective is to do an evaluation which is based on various sources of evidence. So the central source of evidence is an ex post evaluation of 12 major antitrust cases. But this is not the only source. This main source is flanked by 3 other sources, namely a statistical exercise over all 108 antitrust decisions of these 20 years, a literature review, and interviews with leading experts. Last but not least, the objective is not just to evaluate, but also to use this evaluation to draw lessons learned and recommendations, which should then ideally feed into the improvement of DG Comp remedy practice on the one hand, and the rules on remedies that the Commission implements. Now, enough of introduction. Without further ado, I pass now the floor to the authors of the study, starting with Francesco Sciardone from Grimaldi Alliance.
Thank you so much, Thomas. Let me take the floor, first of all, saying thank you to you and to your team for the clear, strategic, and always positive guidance given during the last 2 years to all of us in providing our study. The pleasure to work together has been only comparable with the honor to provide this study to the DG Comp and to be happy to have done a work never done before. So to look at the past in order to understand how a change game like the Regulation 1/2003 have been applied during the last 20 years by the European Commission. The study have been organized in a very simple but on the same time clear way. The context of the execution and implementation of the regulation has been clear to everybody during the last 20 years, but never has been provided an ex post evaluation of the remedies provided by Article 7 and Article 9 of the regulation. The importance of the study is not only to provide, let me say, our opinion, but to provide to the European Commission and to the entire community of the stakeholder of the antitrust bubble a never available before tools to understand how this complex execution of decision taken on the basis of Article 7 and Article 9 have been applied during the time. Everybody already know the study and read every page of the study, I imagine. But to simplify the content of the study is very easy to go through and to go through the simply and very clear numbers that have been applied. So 120 economic and legal articles review, a number of scholars, practitioners, and officials, written interviews, 100 decisions reviewed, and 12 in-depth case studies. This is a very pragmatic approach, the one that had been agreed with the European Commission during the time. So it's a fact evidence study done in order to provide the best background for the lesson learned and recommendation provided as well. A novel dataset of the EU antitrust decision of the last 20 years has been organized and provided and is now available, obviously, to be maintained, updated. It's a need, but cover until the end of 2022. Two-level typology for competition concern and remedies have been analyzed. The 12 in-depth cases have been selected on the basis of well-grounded methodology approach. What we believe is that they are absolutely important to understand what is work and what doesn't work during the last 20 years. The approach of the study, let me state in a very simple way, is very courageous from my point of view for the European Commission. They decide to know the story of the implementation of the Regulation 1/2003 to better organize the future of the antitrust enforcement. And as already said by Thomas, to know the history is the best way to prepare the future. And in my opinion, the legal contribution as well as the economic one that we are able to provide with this study is perfectly in line with the aim to have a better implementation of the well-known antitrust rules, and especially the very effective provision provided by Article 7 and Article 9, as well as by Article 8. It's not the case in this with expert discussion of today to go through detailed analysis of Article 7 and Article 9. But there is a clear difference between the two provisions that we analyze in our study, as well as there is a clear intervention, a clear difference with the approach taken in the merger control as far as structural remedies are concerned compared with the behavioral one. Why these differences and which the effectiveness of the implementation of the decision taken on the basis of Article 7 and Article 9 is the focus of the study provided. For example, just to give you a few highlights and to take the minimum necessary time to leave the floor for the discussion, it's important to underline, in our opinion, how important is the strict application of the proportionality principle for the remedies. As well as important is to reflect and to discuss for the future about the statutory subordination of structural remedies with the behavioral one. Exactly the opposite is said for what is provided in the merger control. On the same time, there is also the need to reflect about the different regime provided for the market test that is required for the decision taken on the basis of Article 9 and not always not for the decision on Article 7. As well as it is necessary to reflect, and Thomas will do it better than anybody else, on the importance of the appointment of a monitoring trustee as a tool important to provide a long-term basis follow-up on the execution of the remedies provided with the decision as well. But as you know, figure and legal basis is not only it's only a part of the mosaicum of our acquis communautaire, and it's important to take lesson also from the extensive literature review that have been provided, as well as of the interview that have been done with all the officials involved in the European Commission in all the cases, on the 12 cases that have been analyzed, as well as with the interview done with stakeholders, practitioners, and officials representing other important antitrust authorities like the French one, the German one, and as well as the US official with whom we have been in touch. All the study have been realized, as you can imagine, on a really strict confidentiality basis, and all the information exchanged and provided have been strictly compliant with the confidentiality requested. The study, going through the challenge identified, and is important to underline that effectiveness and timeliness are perhaps the two most important concepts that have been more and more discussed between all our team. But what clearly could be considered the first and important lesson learned is that a very important focus has to be given by the European Commission when the designing of a correct package of remedies is provided, because the correct design of the remedies provided is a fundamental momentum for the effectiveness and timeliness of the remedies themselves. In this perspective, for example, the first Microsoft case on interoperability, as well as the first MasterCard case, demonstrate how delays in designing and implementing remedies can weaken impact and effectiveness. So the goal of the remedies in a very simple approach from the design of the remedies themselves is to stop the anti-competitive behavior, preventing the infringement from happening again, or to provide a direct prohibition to be circumvented, and possibly removing the anti-competitive effects of the antitrust conduct. As said, it is important to always have clearly in mind the importance of the proportionality principle that otherwise could have an important impact in terms of litigation arguments to be used before the European judge. A number of decisions, is important to remember, have not been analyzed due to the existence of important litigation already decided or ongoing before the European Court. And important is as well, in my opinion, discussing about remedies, that the European Commission can take care of a more cooperative, generally saying, approach with the undertaking concerned, in order to limit as much as possible litigation in decision concerning remedies. But jumping to the choice of the remedy type, it's important to remember that there are three main remedies types to be considered, like cease and desist orders. The behavioral one, these include measures like price caps applied, for instance, in the Aspen case, or behavioral remedies with structural elements. References to the case analyzed in the BAAA. So in the aviation sector. Structural remedies, which are designed to tackle competition problem at their root, obviously, could be checked and verified in the implementation done, for example, in foreclosure case ARA foreclosure case analyzed in our study. Let me underline that the experience done clearly demonstrates that the structural remedies has to be recovered, perhaps, as a comparable solution with the behavioral one. Let me say the only possible application of the structural remedies only when is not available a behavioral one as provided by the regulation is perhaps something on which in the legge ferenda perspective is important to give more attention. Just to complete my intervention, I want to underline as a very important point the decision to be taken by the Commission when legal instrument and procedure is decided to be applied, so to follow the regime of Article 7 and Article 9. There is a need in balancing legal instruments, remedies, to be effective and timely in facing the antitrust concern, and having clearly in mind that as soon as possible a remedies approach is agreed, like in decision on the basis of Article 9 adopted, the better is for the market impact that this kind of decision could have. A mix of factors has to be considered by the competition authority, obviously in aligning remedy design with the remedies objective and contributing to the implementation of the remedies, as well as on the survey of the execution of the remedies itself, to the effectiveness of the remedies. Overall, what we clearly understand by the analysis of the 12th decision chosen as significant for the qualitative approach applied in our study is that the importance given by the Commission in the phase of adoption of the decision, as well as of the litigation before the court, has to be retained as well in the execution phase as far as the remedies decision are concerned. So it's important to think as a straightforward thinking like Thomas is for sure, and the European Commission demonstrate to be, also giving a clear message, in my opinion, to the stakeholders and to the market that the important is not only to adopt decision, but also to provide all the necessary attention in the execution phase as far as remedies are concerned. This is perhaps one of the most simple but factually based evidence reached on the basis of our study. Now I want to leave the floor to Nicola Tusini to perfectly manage our team during the time to go through the financial statistic and, let me say simply, figure of all the studies. Please, Nicola.
Many thanks, Francesco, and many thanks also from me to Thomas Deisenhofer, who, as already said, guided and supported us through this long journey. As anticipated by Francesco, one of the 4 pillars of our study is a novel, detailed, and comprehensive data set of all 108 non-cartel Article 7 and Article 9 decisions adopted by the Commission between the 24th of January 2003 and the end of 2022, including 63 remedies decisions. And based on a textual analysis of the public version of all of these decisions, we constructed a 2-level typology of the competition concerns and of the remedies in each case. And let me now briefly show you some of the statistics that emerged from the dataset. In the figure to the left, we see the distribution of remedy type by legal instruments, so Article 7 and Article 9. And we see that most Article 7 decisions feature just a cease and desist order, where basic orders have been replaced over time by so-called like object and effect orders, which also prohibit conduct having the same or equivalent object or effect. Positive Article 7 remedies, that is, remedies going above and beyond the simple cease and desist order, have always been behavioral remedies with a single exception, namely the ARA foreclosure case, which followed the cooperation procedure. Behavioral remedies are also much more frequent among Article 9 decisions, where, however, we find as well a number of structural remedies and what we call remedies that are behavioral but with structural elements. And turning to the figure to the right, we see instead the distribution of remedy type by legal basis, so Article 1 or Article 102 TFEU. And the fraction of positive remedies is higher in Article 102 than in Article 101 cases. And moreover, all of the 7 structural remedies that were imposed based on Article 102. And as Tom Hearn will explain shortly, the appointment of a monitoring trustee is a flanking measure to the main remedy aimed at enhancing compliance. And as a premise, no monitoring trustee has been appointed in an Article 7 case since Microsoft 1 back in 2004, where the appointment of the monitoring trustee was annulled by the General Court. In Article 9 cases, we can see in the figure to the left that a monitoring trustee was appointed in about a half of the behavioral cases. Most behavioral cases with structural elements and all structural cases. We can also see in the figure to the right that the frequency of the appointment of a monitoring trustee has gone up over time, with only 2 cases without a monitoring trustee under Commissioner FSTE, in particular container shipping and Broadcom, which had started as an interim measures case. And from the universe of all of these cases that I've just described, we then selected respectively 5 Article 7 and 7 Article 9 cases as the basis for the ex-post evaluation of remedies implementation and effectiveness in the individual cases, which is really the main pillar of our study. And after excluding simple cease and desist orders, as well as decisions under judicial review at the time of case selection, and decisions fully or partially annulled by the EU courts, it was, in fact, very straightforward to select 5 of the 7 remaining Article 7 cases. In contrast to that, excluding decisions under review at the time of selection or annulled still left us with 49 cases to choose from among the Article 9 cases. And to select the 7 most important ones, we then constructed a quantitative index combining a range of factors, ranked the cases based on the value of this index, and then selected really the highest ranking cases, while at the same time ensuring a certain coverage over time by legal basis, by type of compensation concern, and by type of remedy. We ended up with 9 Article 102 and 3 Article 101 cases, corresponding to 9 purely behavioral remedies, 2 behavioral remedies with structural elements, and 2 structural remedies. And the discrepancy between the number of cases, so 12, and the number of remedies, 13, is due to the fact that in the Microsoft 1 case, we consider both competition concerns and their respective remedy. The case studies aim to elicit the extent to which remedies in the individual case were implemented by the concerned undertakings and were effective in attaining their intended objective, drawing primarily from in-depth interviews with the case teams, the decision addressees, and market participants. And we could not reach firm conclusions only in one of these cases, namely the Broadcom case, which started as the only Article 8, so interim measures case, decided to date under Regulation 1/2003, and where the remedy obligations are still ongoing. And while our standard for effectiveness was the Commission's intended objective, broader measures of effectiveness can also be conceived, including, in particular, the impact that the remedies may ultimately have on the markets concerned by the infringement, and the influence that decisions containing the remedies may ultimately have on subsequent guidance, jurisprudence, and sector regulation. But on the back of the rigorous case selection and the relatively good coverage of the sample of cases that we selected, we also attempted to challenge a little bit the idiosyncratic nature of each individual antitrust case and find more general patterns. And perhaps let me now briefly show you some of the patterns that we have found. Overall, while 3/4 of the retrospectively evaluated remedies were fully implemented, and that is the figure to the left, less than half of them was fully effective, and this is the figure to the right, suggesting, given that implementation was full, that remedies design may have not always been well suited to the remedies intended objective. And diving a little bit deeper into the statistical results across the case studies, and looking at the figure in the top left corner on this slide, we note that the remedies that were imposed under Article 7 show more numerous and more severe issues of implementation than remedies that were made binding on the undertakings under Article 9. And jumping now to the figure in the bottom right corner, we also note that purely behavioral remedies were less effective than structural remedies or behavioral remedies with structural elements in our sample of evaluated cases. And lastly, the remedy practice of the Commission appears to have improved over time, since issues related to the implementation and the effectiveness of remedies appear to be concentrated in the earlier cases. But perhaps let me stop here and give the floor to Tom Hearn, who will tell us more about the study's findings on the monitoring of compliance with the remedy obligations. Thanks.
Thank you, Nicola. I have the pleasure to present some of our findings regarding remedy implementation and particularly monitoring of compliance. And I do this specifically with reference to the involvement of monitoring trustees, independent advisors, and technical experts. And my first basic point is that antitrust remedies are only effective if they are implemented properly. So when designing remedies, it is crucial to make implementation verifiable with clear mechanisms and flanking measures in place. This is a message that was received loud and clearly during our study, including the 12 case studies. Another point on the next slide is to highlight the value of independent technical advice, or independent advisors and technical advisors already during the remedy design stage, especially in complex sectors like tech and digital, where a rapid change and complexity are the norm. Experts interviewed for this study confirmed this with reference to more recent practice in EU merger control and antitrust cases. So, for example, in Bayer Monsanto, the commitments offered by Bayer provided for the appointment of an independent advisor in order to provide independent advice and assistance to the Commission, regarding one, the adequacy of the commitments, and two, the suitability of the proposed purchaser. And similarly, in the Google shopping case, an antitrust case, the Commission explicitly stated in the decision that it may use the services of one or more external technical experts to evaluate the measures proposed by Google to comply with the decision. And my next point is about the appointment of monitoring trustees, which our study confirms are very valuable, particularly in complex cases. When implementation is very technical and time-consuming, a well-supported monitoring trustee team can act as the Commission's eyes and ears, ensuring compliance and offering initial points of contact for third parties. And this boosts both efficiency and transparency. However, as shown by Nicola, compliance monitoring by monitoring trustee isn't yet standard in antitrust cases, except more recently under Article 9. And in contrast, merger remedies have included such mechanisms as standard since the 2004 merger remedies notice. I want to make 2 points regarding monitoring trustees. One is, while I've worked as monitoring trustee since 2002, I, nor does the study advocate a one-size-fits-all solution. There are alternatives which can be effective in certain circumstances. And the slide shows here that regular reporting to the Commission by undertakings where relevant information and well-defined indicators can already be valuable. Also, monitoring through interested third parties, beneficiaries, for example, of the commitments or access commitments, supported by effective dispute solutions, and arbitration and mediation can be very effective. Then we have the appointment of monitoring trustees and enhanced monitoring by technical experts. And finally, it's worth just looking across the pond, where in the US, the appointment of a technical committee has been undertaken or applied in certain cases, most recently in proposed Epic versus Google decision. The next point is regarding the scope for external monitoring of compliance in Article 7 cases. Here, Nicola pointed out that no monitoring trustee has been appointed under Article 7 since Microsoft won. The General Court there ruled that the Commission cannot delegate powers. It doesn't have the authority to confer on a third party or require undertakings to cover monitoring costs. So this is not a comment on the Microsoft case study, by the way. This is a comment on the Commission's practice since the General Court ruling in 2007. So as a result of this ruling, the Commission and its interpretation of that decision weighs up, it has to weigh up the costs of monitoring when choosing between Article 7 and Article 9 enforcement. And in our study, some experts suggested that this restrictive practice could be reviewed either through a reinterpretation of the decision and the current rules, or by amending Regulation 1/2003 to allow for monitoring costs to be shifted to undertakings. This concludes my comments, and thanks for the opportunity to provide these comments, and I hand back to Francesco.
Here I am. So the effort done with our study, as said, has been primarily focused not only to take note of the lesson learned, but to provide to DGCOM and to Thomas and his equipe a series of recommendations that could be useful for the future of the implementation of Regulation 1/2003. The lesson learned simply resumed in this slide will be of help to understand how important it is for the enforceability that the remedies should be practical, not overly costly or complex to implement. It could be considered as a simple statement if you want, but if you give a look to the complexity of the remedies providing on the basis of the decision analyzed and generally saying on the experience of the implementation of the antitrust rule, you have to take note that to be simple and to be effective, to grant enforceability, it's perhaps the most important lesson learned that we want to underline for the webinar of today and overall for the future of the implementation of Regulation 1. Timeliness as well is, let me say, a necessity. Remedies must address competition concern in order to be timely in facing the need of the market, the right moment for the implementation, and this is more and more true in fast-paced markets. Everybody knows how the market are changing and how important it is for the competitors, for example, as well as for consumers, to be granted by timely and enforceable remedies. The evolution of the remedy practice is more or less confirming what I'm saying, because older cases showed more issues with implementation and effectiveness compared to the recent one. And it does mean that the Commission confirmed the attitude to learn a lot from the experience done. It's important to remain, as well as said already, focus on the broader impact, because remedies can influence future guidance, judicial decision, and sector regulation. The experience done with the MasterCard case clearly confirmed that there is a need to be aware of the general impact in terms of also regulation that could be provided by well-designed, well-applied, and timely enforced remedies. General recommendation. I stop with only the first general recommendation that you have on the slide, but it's important that the remedy objective is clearly mine when is designed. This is also, say, a simple statement, but is important as well. Often we have seen that remedies are not so well focused in terms of objective, and it's important to say from a strict legal point of view that the remedies has to be necessary for the objective of its adoption. So the aspiration of the antitrust remedy should always be not only to stop the anti-competitive behavior, but also to prevent its repetition and to remove the detrimental effects on the market that is caused whenever feasible. The effectiveness has been mentioned more and more, but it's important to restate that this principle is a fundamental principle in the design of the antitrust remedies. There is no need to have remedies if they are not effective. There is no need of remedies if they are not enforceable. There is no need for remedies if they are not timely provided to be effective on the market. It's a very, if you want, simple but important way to think about general recommendation. But if you can go through the 100 of pages provided with our study, you can see how often these three concepts are important in order to check and verify with the advantage of our ex post analysis that if at the very beginning the approach taken in the designing of the remedies and in the also adoption of the decision on the basis of Article 7 and 9 have been provided, the effectiveness, the timeliness, and overall the enforceability of the remedies completely change. So the advantage of our ex post analysis is important because it has to be helpful for the future. This is my last slide, and I leave the floor to Nicola to go ahead.
Many thanks, Francesco. And let me perhaps concentrate on Article 7, because while we learned many lessons in our research, a number of them point to the imperfect functioning of Article 7. And our study finds that this imperfection is due to multiple reasons, which are related to the hybrid nature of the instrument, which at the same time establishes the infringement and possibly imposes the remedies. They already recalled statutory subordination of structural to behavioral remedies in antitrust. No requirement of market testing, unlike with Article 9, and the constraints on the appointment of a monitoring trustee placed by the Microsoft One judgment. And precisely to overcome these limits, our study recommends, and this is our recommendation number 4, that irrespective of remedy type, remedy choice be left to the application of the principles of effectiveness and proportionality in the individual case. And this is in line with what Article 10 of the ECN Plus directive already says. The study also suggests, and this is our recommendation number 6, that in order to allow for a dedicated effort on remedy design and increased transparency, the infringement decision could, in particularly complex cases, be separated from the remedy decision. And finally, and this is our recommendation number 7, remedy design under Article 7 could benefit from the type of market testing that is already required under Article 9, by Article 27.4 of Regulation 1/2003. But let us perhaps hear from Tom what some of our further recommendations emerging from the study are. Thanks.
Thank you, Nicola. Let me close this presentation by listing selected recommendations regarding modalities, flanking measures, and other recommendations that reflect our findings presented earlier. Recommendation number 12 is about reporting obligations, which should be included in Commission decisions as a standard practice, including simple cease and desist orders. The next recommendation is about the appointment of monitoring trustees. That should be standard practice in both Article 7 and 9 cases, unless strong arguments exist against it. And here, the role of the Commission in the appointment process should be strengthened. For example, the Commission could request multiple monitoring trustee candidates, have the final say in the appointment, replace monitoring trustees if issues arise, set clear boundaries of the powers of monitoring trustees, appoint technical experts as needed, and finally establish suitable governance systems for monitoring and the role of the monitoring trustee for complex cases. Recommendation 14 is about the appointment of independent advisors to the Commission in the remedy design phase. That should be considered in complex cases. And finally, recommendation 15 is the consideration of the publication of antitrust remedies guidance by the Commission, similar to the merger remedies notice. This, in our view, could provide significant benefits to all parties, enhance remedy implementation and effectiveness, and speed up the remedy design process. Thank you.
So thank you very much to the authors. We are unfortunately a bit over time. So I've seen some questions in the chat, and they're good questions. What I propose is, because we are over time and we want to hear from the panel, that I will give these questions to the panelists also over. And so the two questions that I would in particular hand over to Damien is what is Damien and the experts? In the chat, one question is, should we either have more structural remedies, or instead of behavioral remedies, or work on the effectiveness of behavioral remedies in order to improve the overall effectiveness of remedies? Another question which I found interesting in the chat was on why would it possibly help to separate the infringement decision from the remedies decision, or does this not really help? Now, before handing over to Damien, I have still to introduce him. So I already gave him two questions, but I still have to introduce him. So Damien is the Prosecutor General of the Belgian Competition Authority since 2021. He's also a well-known practitioner. He worked before at DG Competition, but also a practitioner of private practice before. And on top of all of that, he is also a brilliant academic career with lots of publication and teaching at the UCL and at the College of Europe. So he's one of the rare persons to combine the practitioner's view, the academic view, and the enforcer's view. And so there's nobody better placed to chair now our panel of experts. And I'm really curious what you're going to make out of this remedy study. And the floor is yours, Daniel.
Thanks very much, Thomas. A very generous introduction, and welcome everyone to this to the second part of this workshop, which will entail an expert discussion of the main findings and recommendations of this study on the effectiveness of EU antitrust remedies. And indeed, so many thanks to those who have already put questions in the chat. We'll keep tracking those, and I'm confident that the speakers here will address a number of them on their own initiative. So as you can see, I'm indeed sitting here in Bruges at the College of Europe. Thanks to the technology, I can be with you all, and it's obviously a great pleasure to moderate this discussion among three very senior competition experts with a very significant experience in designing and implementing remedies. I will not introduce each of them extensively, but they each wanted to disclose the involvement in some cases in the past and ongoing. So Vanessa Turner, in her capacity as a senior advisor for competition at BEUC, the European Consumer Organization, is currently involved in a number of prominent EU antitrust cases on behalf of European consumers. And she wanted to disclose also that prior to joining BEUC, she's been a partner in the competition practice of two prominent international law firms, a member of the cabinet of Commissioner for Competition Policy Neelie Kroes, a special advisor to the US FTC in Washington, D.C., and a general counsel at Visa Europe. Justin Menzies, so partner with Forvis Mazars, one of the prominent monitoring trustee, also an independent advisor in relation to remedies and compliance, wanted to disclose that he has served as monitoring trustee to the Commission in various cases, including some which are discussed in the EU antitrust remedy studies, notably BAAIB. And he's also one of the co-author of the 2005 merger remedies study that dates back to his time at DG Comp. And Bernd Meiring, as a senior partner with Linklaters, and also a visiting professor at the College of Europe, I wanted to disclose that he's also, or he was and still is, advising companies in various matters involving remedy design and implementation, including cases discussed in the study or not, such as, for example, the Google Shopping case, which has been excluded from the scope of the study because he was still under appeal at the time the study was carried out. Now, thanks a lot to all of you for joining this panel. Let's start immediately with your views on the findings of the report. That is mainly the challenges and best practices part of the study and the exposed evaluation of the 12 selected significant remedy cases. So in particular, I mean, did you find the study too critical or too soft or more or less right on the overall assessment of the effectiveness of EU antitrust remedies? I don't know if you were surprised by some of the findings or if you found that anything was missing. So let's turn maybe first to Vanessa. What's your take, Vanessa?
Me to join you today. I've long held the view that remedies have been the poor relation in competition law enforcement. And in 2020, I wrote an article on the issue of remedy effectiveness, or rather the lack thereof. So that the Commission has now done this ex post review of remedies is most welcome, even if it's 5 years after I suggested it. And I would like to commend the authors for doing an excellent and certainly not easy job in this study. But having looked at this issue previously, I have to say that the findings in the study are not a surprise to me. And I'll pick out 4 of them that I found most striking, some of which have already been mentioned by the authors of the report. I think the first striking finding in the report is that fewer than half of the cases reviewed in detail, so the 12, in fewer than half of those were the remedies fully effective in achieving their goal. And for me, this is actually quite an indictment of EU competition policy and, in fact, underlines the need to have done this study. From the consumer perspective, and I think also from the competition policy perspective, there is little point in bringing a case and finding an infringement, taking up enforcement resources for several years, if this does not do anything meaningful to deal with the issue, or as Article 7 of Regulation 1 puts it, to bring the infringement effectively to an end. Furthermore, if companies, I think, believe that even if they get caught infringing the law, the remedy is likely to be ineffective, then the deterrent effect, one of the objectives of remedies, will also be diminished. I think the lack of effectiveness of remedies may have several origins, and this has come across already a bit in the debate. The debate on remedies, whether this involves lawyers or academics or economists, has to date focused on the issue of proportionality of remedies and the structural versus behavioural remedies debate, as we again illustrated. And I think this at the expense of the effectiveness requirement in Regulation 1. And if we look at court appeals, these have also focused more on proportionality. And I guess that this is a reflection of the incentives and interests of the authors or infringers of the law. Now, obviously, proportionality is essential, and of course, it's mentioned in the first recommendation in the report, but we'll come back to the recommendations later. But I think the ineffectiveness of remedies can't be blamed solely on infringers and their advisors' incentives. I can see that some issues on the regulator side, both in particular process points, could be improved to reach better outcomes, as also identified in the report. So I think that would be my first observation. My second pick for the findings would be that purely behavioural remedies were less likely to be both fully implemented and effective than other forms of remedies. At the same time, however, the study found that behavioural remedies were the most used type of remedy. So for me, this definitely means that it's essential to try to improve behavioural remedies. Another finding that struck me was, and I think this has been mentioned less, is that remedies going beyond cease and desist orders were imposed in only 20% of the Article 7 decisions. Limiting remedies to cease and desist orders seems likely to be one of the causes of ineffectiveness of the remedies. And the study, in my view, rightly notes that positive remedies may be required that specify in more detail what undertakings will need to do, including measures to prevent repetition and circumvention. And in some cases may also need to be restorative, the restorative function being explicitly noted in the ECN Plus directive. And I think the case law also clearly supports the Commission's ability to go beyond cease and desist orders. Therefore, I think that will be another point to look at very closely in future remedies. And I note actually in passing here that the Facebook Marketplace decision we've just published a few days ago appears to go down a greater kind of specification route. So the fourth finding that struck me was that prohibition decision remedies are less well implemented and less effective compared to remedies and commitment decisions. And I suspect that this is linked to design issues and due to lack of consultation of third parties and with the absence of monitoring trustee, as noted in the study. Now, I could go on to many other points, but I'm actually going to end by suggesting that in light of the findings of this report, the Commission should, in fact, not wait too long to repeat such an exercise, particularly for remedies in digital markets. First, because many of the more recent tech sector cases were excluded from this study, and several of those have been mentioned. And second, because of the 6 tech sector cases studied in depth in the present report, only in 1 were the remedies found to be fully effective, and that's a lower success rate than for the non-digital cases. So I'm sure that looking at digital cases not covered by this report could be quite instructive, maybe not only for antitrust cases, but potentially also for the DMA. And I'll stop there.
Thank you, Vanessa. And your last comment echoes a question in the chat as to avenues for future research. So typically, expanding the sample, looking more closely in certain sectors, are all possibilities out there, which would definitely enrich the findings of this study. Moving to Bernd, any surprises, concerns, or other methodological comments on the finding of the study? Just pointing also that there is a comment in the chat as to why were cartel cases excluded from the scope of the study, which is maybe a point you may want to tackle.
Yes, thank you, Damien. Indeed, so surprises. I mean, first of all, congratulations, I would say, to the authors of the study. Having done this is a great achievement, and it does show some patterns that you don't see if you're in the trenches on these cases and look at the decisions individually. And then also there is that tendency, once the Commission does a case, it takes years, it's very resource intensive. Once it's done, many people move on and don't really look at what happens then. So it's really important that is being done, because if so much effort around enforcement and process then leads to something that is only half effective, there is a question around what the administration, but also what companies spend their time on at the end of the day. So I think that was maybe already a first remark. I was planning to make 4 others. One on what we are talking about. And when I read the report, there are these distinctions, but what we think of when we talk about remedies are actually quite different things. There is the basic cease and desist. And even in these cases, very often what companies do once they have gotten a cease and desist is called a remedy, even though we would probably not talk about a remedy in the decision if it's only a cease and desist, and that wasn't really studied in depth in this study, but companies think of it as remedies, and there are some issues there around remedy effectiveness as well, the basic cease and desist. That brings me, Damien, to your question around cartels. I've been thinking, why are cartels excluded? I mean, of course, you would think that a cartel case is the typical case where a basic cease and desist is fine, and it's not really very interesting to study effectiveness, because I would assume, well, not having studied it, and it's hard to study, but I would assume that you have a very high rate of effectiveness of cease and desist in cartel cases, in particular since most of them still come from the leniency system. So I do understand that intellectually it might not be the most interesting field. I think, however, cartel cases are something to bear in mind, because it shows that cease and desist orders have their place in the enforcement system. That brings me to then the remedies that you have in Article 7 and Article 9. I think Article 7 is very clear that the objective of the remedy is that the infringement ends. And the language is very clear. It needs to end effectively, and that qualifies. But the purpose is to end the infringement. The term is not to regulate. The term is not to make markets work as much as we would want that as competition lawyers. The purpose is to effectively end the infringement. I think then when it comes to cooperation in Article 9, there is more flexibility, of course, because this is something that companies do in order to avoid the fines and sanctions that you would typically have under Article 7. And there you might give some credit for making competition work beyond just ending an infringement. And that basically, these have been very useful tools in the past. But I do think it is important to really keep them apart and not to lump them too much together. And that when we talk about the objective of Article 7 remedies, even from a legal perspective, those are different from what you might be able to bring into Article 9 and cooperation remedies. I then finished with remedy compliance. I mean, effectiveness is one thing, compliance is another. And if a remedy is not effective, that can have many reasons, from the design to implementation, monitoring. But when there is no remedy compliance, that is really quite a worrying thing. And I was personally quite surprised by the significant number of cases of non-compliance in the study. But I'll stop here so that to make sure that we also can get to recommendations.
Thanks, Bernd. And obviously, if some of the authors of the study want to comment at some point, feel free, including in the chat. But let's turn to Justin. So from your experience and your involvement in some of the cases also reviewed by the study, what's really your assessment of its findings?
Thank you, Damien, and good afternoon, everyone. It's great to be here today speaking to so many participants. I thought I'd share that back in 2005, as Thomas mentioned, I was a co-author of the merger remedies study, and that was a commission staff paper drafted by commission officials. And I can really see the benefit here of having awarded the study to an external contractor, because it resulted in much more openness from contributors and in particular interviewees, perhaps due to anonymity and confidentiality and interaction with authors who were independent of the commission. And the team spoke to a broad base of stakeholders and parties to commitments and monitoring trustees. So the authors managed to get more of an insight into, for example, the objectives of the commitments. So I can see that the evidence on which the study's findings are based is good, particularly the wide-ranging interviews. I can only comment on a few aspects of the study, and I'll concentrate on aspects relating to implementation. So first, as a firm acting as a monitoring trustee and an independent advisor on cases across the world, we recognise the implementation challenges identified in the study. And it will not be surprising to hear, and I hope it won't be seen as overly self-serving for me to say, that I agree with the study's conclusion that the appointment of a monitoring trustee to oversee and report on implementation is useful, particularly when the remedies are complex and the verification of implementation is technically demanding. And we absolutely agree with the study's conclusion that it's important that the monitoring of remedies is supported by suitable technical and industry expertise. We regularly supplement the expertise within our team with the involvement of industry experts. And just one example is Bayer's acquisition of Monsanto, which is mentioned in the study. And there, it was really helpful to be supported by a technical expert who was a university professor and an expert in plant breeding science, who was able to evaluate the proposed contents of a divestment package from a highly technical standpoint, to enable the effective implementation of the commitments. Second, in terms of implementation challenges, the study concludes that structural remedies are easier to monitor than behavioural ones. And we absolutely recognise that with complex behavioural remedies, there's a risk of circumvention, and that behavioural remedies are, as a general proposition, trickier to monitor. The challenge increases with behavioural remedies of longer duration. And in such cases, it's critical to agree on an appropriate framework for the implementation and monitoring, and to be able to adapt with the agreement of all stakeholders in case facts change or market conditions evolve in a way that was not foreseen at the time of the decision, while at the same time ensuring that the objective of the commitments is fulfilled. But the implementation and monitoring challenges raised by structural cases should not be underestimated. In particular, it can be sometimes difficult to find a suitable purchaser for a divestment business, and the study highlights the Eni case, where Eni committed to divest its shareholdings in companies related to international gas transmission pipelines, and the study found that the divestiture to an Italian state-owned company might have diluted the effectiveness of the remedies imposed. The updated model text for divestiture commitments under the merger regulation introduces a more stringent purchaser requirement. For instance, when it comes to financial resources, the purchaser needs now to have a turnover significantly larger than that of the divestment business, but must not be excessively leveraged, and must have sufficient equity and profitability. There is also now an explicit requirement for the purchaser to have the ability to develop the divestment business as a competitive force, supplementing the pre-existing requirement for proven expertise to do so. So we would expect to see correspondingly more stringent requirements in divestment commitments in an antitrust context. Third, the study also references the importance of flanking measures for the effective implementation of remedies. Examples include arbitration clauses, quick enforcement mechanisms, and transparency measures vis-à-vis competitors and consumers. We're seeing more of such measures included in the design of commitments, and consistent with this trend is the inclusion in the recent updates to the Commission's model text for divestiture commitments under the merger regulation of a new dispute resolution procedure, which comes into play in the event of a dispute in relation to the commitments. So the Commission seems to be more alive now to the benefits of these types of flanking measures. Lastly, I also agree with the observations of the Commission case handlers mentioned in the study that remedy implementation can be strengthened by enhancing certainty of the enforcement of behavioural remedies. However, notwithstanding these additional procedures, the Commission will still have an important role to play. For example, a fast-track arbitration procedure can effectively resolve disputes between the parties. But if the dispute is about the interpretation of a clause in the commitments, then arguably the best placed party to resolve that is the Commission itself. And the study mentions an extensive arbitration at the ICC, which was resolved when the Commission provided a one-pager clarifying the interpretation of the clause in the commitments, which the authors say suggests that the Commission should be more proactive in clarifying the interpretation of commitments early in the process. So these are just a few thoughts on the findings of the study. Many thanks, Damien.
Brilliant. Thanks, Justin. Maybe just two very quick comments from an NCA perspective. I mean, first of all, you know, the study is really extremely valuable, because even if the bulk of antitrust enforcement is done at national level, I mean, very few competition authorities have really in Europe the means, the resources to carry such a study. While at the same time, the practice of the European Commission remains really a model for NCAs that NCAs seek to emulate, and which at least provides a very solid benchmark on what the good practices are. So these are resources very well spent, and so many thanks again to DG Comp and the authors for putting it together. Now, quick second comment: at national level, the idea still lives on that behavioral remedies are, you know, generally more appropriate and certainly more proportionate than structural one. And it's really telling, I think, that one of the main findings of the study is that there is a clear difference in effectiveness between structural and behavioral remedies, also in antitrust cases, that structural, or at least, you know, remedies that have a strong structural element are are more effective. And I think that's something that should definitely percolate at national level. Let's turn to recommendations now. Now there are 18 recommendations formulated in the report, so spanning a range of topics relevant to infringement cases, commitment cases, interim measure, as well as remedy design and implementations issues generally. We have 10, max 15 minutes, I suppose, Thomas, to try to comment on some of them. Let's go back to Vanessa. Any particular recommendations you'd like to highlight or that you think might be actually missing?
Thanks, Damian. I'll try and be brief given our lack of time. So let me start by saying that I agree with pretty much all of the report's 18 recommendations, but I'll highlight just 3 of them, number 2, number 7, and number 18. And I think in the process of doing that, that will also answer Thomas Deisenhofer's questions that he put to us from my perspective anyway. And then I'll go briefly to what I think is missing. So first of all, I strongly support recommendation number 2, which is that in line with the legal framework, the principle of effectiveness should at all times be taken as the fundamental guiding principle in the design of antitrust remedies. I think that probably answers the first question as well. I think that is the overriding requirement, and together with actually the timeliness point made by the authors of the report as well. And I think there are a number of or other recommendations which could all contribute to that, notably number 12, 13 and 16, so reporting obligations, monitoring trustee and ex post evaluation, but I think I better in the interest of time not go through those. So if I then go to my second pick of what I really liked in the recommendations, that is recommendation number 7, so market testing remedies under Article 7. I think this is essential. Third parties should be involved in remedy design, similarly to Article 9 remedies cases. And for me, relying on infringing companies to propose remedies, relying only on those companies to propose remedies, given their superior technical knowledge compared to the Commission and commercial incentives not to make remedies too effective, always seems to be suboptimal to only rely on them. Therefore, consulting third parties should be part of the process under Article 7 as well. I think that would have avoided the ineffective remedies we saw in Google Shopping and Google Android, and notably in the latter case, the remedy was revised 2 years later after consulting third parties. I know third party consultation will take a bit of time, but it's still going to be better than a delayed effective remedy on the market. That could be combined with recommendation number 10 on simplification of market testing under Article 9. For my third pick, I do like recommendation number 18, that the Commission consider setting up a dedicated unit to support case teams on remedy design, implementation and effectiveness across all relevant EU competition policy areas and practices. And here I agree with Bernd. I think case teams' incentives are inevitably to do their headline-grabbing prohibition decision, and there are fewer incentives to design good remedies, and perhaps even fewer incentives to follow up on remedies and make sure they're working. And human nature, I guess, suggests that if you've spent years investigating a case and getting a decision adopted, fatigue may set in with the subject matter and combined with the understandable desire to move on to another case. So therefore, I think that having a group of remedy specialists to design and monitor compliance would be beneficial, similarly to the case, for example, in the US at the FTC Compliance Division. Very briefly, turning to what I think would have been nice to see in the recommendations as well, but may not have been possible in light of the selection of cases, and that is, I would add a recommendation which I hope the Commission will consider, is that remedies in consumer-facing markets, in particular in the tech sector, must involve systematic consideration of behavioural economics or behavioural insights, however you want to term it. I mean, the key role of consumer behaviour has been recognised in theories of harm, think notably of Google Shopping or Google Android again, but behavioural insights I don't think have been yet systematically applied in remedies, and I think that would be an important idea to add. And then finally, very specifically from the consumer perspective, the report notes that, and I'm quoting here, even in the case of a restorative objective, remedies are forward-looking and do not, foresee the disgorgement or restitution of historical anti-competitive gains or the compensation of historical competitive harms. And my question would be, why not? This is consumers who are meant to be the ultimate beneficiaries of competition law enforcement.
We seem to have lost Vanessa in the middle of a sentence.
Other jurisdictions operate. I think I just got cut off there. I don't know how much you heard.
You're back.
Which bit did you miss? Or maybe I should stop in the interest of time. I'm saying we should have a disgorgement remedy in addition to a recommendation, in addition to the rest, under the review of Regulation 1, and I'll leave it there.
Brilliant. Thanks, Vanessa. Bernd, let's move directly to you. Any particular recommendations you want to highlight or concerns that, based on your experience, companies might have while reviewing these recommendations?
Maybe 6 quick points from a user perspective, and this is complainants or addressees of remedies alike, and very much driven by effectiveness considerations on both sides. I think the first one, I already alluded to it, link to the objective and whether this is about ending infringements or going further, and you partially move into that regulation space. I think that needs to be very clear from a legal basis perspective, and then also from a remedies perspective. I personally have sympathy for not distinguishing between behavioral and structural at the level of the text, but I find it very hard to think of an Article 7 case where a structural remedy that is not offered in cooperation could be proportionate. I just can't think of a case. If we bring towercast type of cases back into Regulation 1, that's another topic, then of course the matter might become relevant, because in these types of cases, structural remedies would be the natural thing to do. But in a case where the behavior is the problem, requiring a structural change to end effectively the infringement, I find that very hard to think. Maybe if you have repeated recidivism at some point, you will say nothing else worked. But it's really a bit of a stretch. So I don't know whether that isn't more of a theoretical problem. Very different for cooperation and Article 9 remedies, where it's really where it can be relevant, I think. That brings me to a quick second point. Formalizing the cooperation procedure. I think I wholeheartedly agree with that. Would be very beneficial for many reasons, not only for remedies, but also for remedies, because these are really useful tools. Currently, it's a bit of a mix between cartel settlements, cooperation, and free flow. You know about what it works, but it's not very clear how these procedures can end. It's mainly talk about fines, not remedies. Bringing remedies into these procedures can only be really very, very useful. Then the remedies compliance unit. I would personally prefer an approach like in the US, where you have somebody who follows up on compliance with decisions, be it remedies, cease and desist orders. I think it is really not satisfactory that large case teams spend years working through a case, working through an industry. A decision comes and then you just move on, and you don't realize when things don't work. I mean, we had a remedy that wasn't implemented for several months. The market didn't realize, and then the company that had to implement it realized. Now, that tells you something that remedy might not have been a great remedy, because if nobody needs it and nobody notices, why do you have it in the first place? But that also tells you something about if you spend so much effort about making a decision, the limited effort and mechanisms to have some grip on compliance is probably a worthwhile investment. A quick word on interim measures. We haven't discussed that so far, but that's also mentioned in the report. And there is that idea that interim measures should really prepare the remedy as well. I personally struggle with that. Interim measures will mainly be relevant in Article 7 cases, I would assume. And in those cases, the purpose of the interim measure is really to prevent lasting damage, to make sure that damage can be undone when the decision is adopted and that it's not too late. What I could see in that vein in cooperation and Article 9 cases is that the Commission says if you want to benefit from Article 9 or from cooperation in this case, then you need to make certain changes to your behavior immediately, because we need to come to a solution where a remedy works. We need to come to a solution where markets work. And if you just add to the damage now, then cooperation or Article 9 might be off the table just because of that. I think it is a similar idea, but I would think interim measures, as we have them in an adversarial setting, they are not the tool to prepare a remedy. A final word on the call for guidelines. I'm not sure whether that wouldn't be putting the cart before the horse. And I don't mean waiting for practice necessarily, but I think we are now reviewing Regulation 1. Some of the things that we've been discussing here will probably find their way into Regulation 1. Guidelines would be useful that then tell us how that will be implemented, but I struggle with the idea of having now guidelines out there and then changing the regulation. That just, to my mind, would create more confusion than clarity. Thank you.
All right, thanks a lot, Bernd. If we have still 2 minutes, we might come back to a couple of points you made. But Justin, obviously various recommendations are being inspired by the merger control practice, where you also have a lot of experience. So what are your takes on some of the recommendations?
Thanks, Damien. So the first recommendation I wanted to focus on is recommendation 5, where in an Article 7 decision post-Microsoft, the Commission does not have the power to require an undertaking to bear the costs that are incurred by the Commission in monitoring. And I note that the study says that as a consequence of the CFI's judgment in Microsoft, the Commission has to take into account the monitoring costs of any Article 7 remedy when balancing the options of pursuing an Article 7 or Article 9 decision, favouring, all else remaining equal, the lower monitoring cost route of an Article 9 decision. And the cost of monitoring does not seem to me to be an appropriate factor in a decision as to what is the effective route for the resolution of a competition infringement. I can certainly see the benefits of making the change suggested by the study, although I recognise it would introduce a cost for business, but that may be arguably justified where the undertaking in question is found to have infringed competition law. The next one I'd like to turn to is recommendation 13, which proposes that the appointment of a monitoring trustee should be the default practice in antitrust remedy cases. I agree with the proposition, which is not to say that I don't recognise that there are clearly some commitments where it is patently obvious what needs to be done and very straightforward to see whether it has been done. And I think Tom Hearn mentioned direct reporting to the Commission, third-party reporting, and an effective dispute mechanism. Then recommendation 14 is one I'd like to look at, which is the appointment of an independent advisor to the Commission in the remedy design phase. And that might be appropriate where the design of remedies may require technical expertise or the implementation might be particularly complex. And I think it's been stressed by Francesco at the beginning that the remedy design is really fundamental to ensuring an effective resolution of the competition problem. And the report does well to highlight the potential contribution of independent advisors. And we increasingly see competition authorities appointing independent advisors, and they can be very helpful in ensuring the proper design. The study highlights that this can be particularly helpful in the tech sector, as it's important that remedies are designed to reflect the technological reality and take account of technological change. From experience with working with technical experts with in-depth knowledge of a market segment can be highly instructive in assessing the appropriateness and the success prospects of a remedy concept. And that supplements market test feedback, which sometimes needs careful filtering. And then I agree with Vanessa about recommendation 18 and the establishment of a unit to provide consistency across remedies implementation. And that may be by parachuting having them involved afterwards. So those were my comments.
Thanks very much, Justin. And just to echo your first comment, I mean, from a national perspective, some companies can be very sensitive to the monitoring or implementation burdens and the cost associated with having an independent monitoring trustee. I mean, have become involved in a number of cases which resulted in disputes really on the need for an independent monitoring trustee and the associated costs. So that's still to keep in mind. And on one of the point Bernd made on interim measures versus change in conduct, I mean, in many of these Article 7 cases, I think companies will be extremely reluctant to change their practice, without a decision, an interim measure decision, because that would or could amount to a knowledge that maybe their practice should indeed be changed to be in line with Article 101 or 102. I mean, I just don't see really how in practice, in reality, we can structure something that would give companies really the incentives to change their practices up front in the absence of an interim measure decisions. And at national level, we have quite some experience with interim measures. Obviously, the effectiveness depends also on the legal standards that are applicable, and but they can really change the dynamic of a case and provide the right incentive to find a solution as well. Now, Thomas, we have already gone a bit out of time, but we haven't really addressed the point on the split between the decision on the substance and the decision on the remedy. Shall I just ask our three panelists just to address that particular point? I don't know, Vanessa, do you have a view on the usefulness or not of deciding separately on the substance and on the remedies?
Briefly, I think, having said that, I think we should have a separate remedies unit. That probably means some kind of a split there, but I guess you would lose some kind of knowledge if you split it completely without having the knowledge how the case got there. So I think there may be a middle way through that you do have a separate unit that brings its expertise, but you don't fully lose the expertise of the case team. So maybe you do have a separate decision, but not completely divorced would be my thinking on this.
So for Article 9 cases, I find it a bit hard to split the two, I must say, because the remedy is a bit part and parcel of the decision. For Article 7 cases, I have a lot of sympathy for the proposal, maybe for reasons that are not exactly the same than that those mentioned in the study, because I do think if you would say we have a cease and desist, a modern cease and desist with prohibition of equivalent measures and so forth, and you would then press pause here and then move into, do we need an additional remedy to make this effective, and what would that remedy look like? I think that would be very healthy, because you can then also see how the cease and desist works. So you can be really targeted and say, if I start investigating after my cease and desist, maybe the problem solves itself, and then I don't need more. If the problem does not solve itself, that immediately shows me that my remedy is proportionate, and I don't have that issue, because I then have a couple of weeks experience with the cease and desist. So I think in Article 7 cases, it is a very good idea to make sure that remedies are effective, but also proportionate and targeted. And for cooperation procedures, I mean, I need to think about in which bucket you would place those.
So I think they say that difficult cases make bad law. But I was a monitoring trustee in the Illumina Grail case, and there, under the merger regulation, the structure of the merger regulation is such that if you have a prohibition decision, you then have a separate article under which you need to adopt a restorative measures decision, and that requires a process of a letter of facts or a statement of objections, an oral hearing, a right to reply in writing, rights of defence, and so on. Which can result in a very deep discussion of the remedy and enable all the stakeholders to be relatively comfortable with the remedy that is finally proposed. So I do see some value in splitting the process in terms of allowing the parties concerned and other stakeholders to have a right to participate in the design.
Brilliant. Thanks a lot. Thanks, everyone. Back to you, Thomas.
Thank you, Damia. Thank you, dear panelists. This was really super inspiring. I took lots of notes. I don't know whether you've seen, I scribbled a lot, and wrote down a lot of things to learn. And thank God, this is for all participants. We will also offer a recording of this workshop on our website. So I will have another look again and listen again, because they were to really capture all the rich ideas that you brought to the table. To conclude, I wanted to make touch upon 2 points. One, I think a fundamental issue that Vanessa started with, and that's the why is it that it's so difficult, at the same time so difficult, and at the same time so important to get it right on antitrust remedies in particular. And there's the difficulty is one basis very similar to mergers. It's you have information asymmetries, so the parties know what's going on in their markets, in their firms. The Commission doesn't. You have the incentives are not aligned at all. You have very diverging incentives. And you have also resource problems, which you may try to address with monitoring trustee, independent advisors, but there is always a asymmetry of resources also. But then in antitrust, it's even more difficult, I would argue, than in mergers, or at least perhaps we haven't paid as much attention to remedies as in mergers. The remedy decision comes really at the end of a very, very long process. In antitrust, what matters a lot is the precedent value, is the fine also, and then the remedy becomes, in a sense, the last thing to consider psychologically. It shouldn't be. It's very important. I come to this, but perhaps psychologically that explains. And in a sense, it's a bit like IT. I don't know whether you've seen it in your organization. If the IT works, if an IT reform works, nobody notices. But if it doesn't work, it's really a big problem. And that's something I want to also echo, Vanessa. If things do not go well on antitrust remedies, and that was also a point made by Bernd, it's bad for all constituencies. It's bad for the consumers. We failed the consumers. We failed the market participants. But also we fail the addressees. And we fail our colleagues in the authorities, because these remedy cases that do not go well, they last years and years and years. They create extra burden. The implementation of a bad remedy gives extra work, distracts from other cases. Take the ARA case, which is a good example in our finding. In 2016, was a remedy which was a structural remedy, and it worked. But it follows a case of 2003, where we had a behavioral remedy exactly on the same issue. And because the behavioral remedy didn't work, we had actually to take 13 years later another decision. And so you can imagine that the whole competition problem, it took 20 years to resolve this competition problem, involved generations of case handlers, because the remedy in the first case didn't work. So it's important. Now, I want also bring one point of optimism into this whole debate, which I haven't heard from anybody of you. I like the optimistic points. I think we are learning. We are a learning organization, DG Competition. One point which has not been made is that the frequency of the use of monitoring trustee has really increased over the years. Nicolas showed the statistic. But also in our sample of 12 cases, the big failures are more in the beginning of the sample. And perhaps also anecdotally, the Microsoft case led to Microsoft 2, the tying case. The tying remedy is a much better remedy than in the first case. So we learn, we improve, and this study is part of our attempt to be a learning organization and to move forward. I see positive elements in recent years and hope that we continue on this important journey. Now, one question which also nobody asked, but which is obviously the important question: will we change Regulation 1, and will we change Regulation 1 at all? And I'm in the comfortable position that I cannot tell you anything. This is the thinking process is still ongoing. No conclusion whether we will change the regulation at this stage. But what's clear is that DG Comp, the Commission, we are very much committed to further improve the effectiveness and the speed of our of Commission procedures, whether or not we will go to the for reform of the regulation. And there, for this effectiveness, speed, this type of study that we did today, that we talked about today, but also this workshop today, which brought a lot of rich ideas, new ideas to the table, will help us, and that I can really promise you, to improve our practices and to get better at what we're doing on this important issue of remedies. Now, I want to conclude with big thanks to the authors of the study who have done tremendous work over these years, 3 years of very hard work, groundbreaking work, not done before. Thanks a lot for the presentation today. Thanks a lot to Damien and the panelists. Wonderful panel. Really, I will take note for many things. Big thanks to the team who has worked on this study in the DG Comp side. I mentioned them: Anna, Sean, Luca, Alex, and Karin, from my team, work on the background, on the tendering, which is a lot of work. And big thanks to the I5 team, there's a communication team who set up this workshop. Before closing, I have an advertisement to do for the next workshop. We have yesterday published an invitation to a workshop on the 10th of April on another study that we conducted over the last years, which is on killer acquisitions in the pharma sector. A fact-finding study where the study has been done by a consultancy called Lear. And we will have an interesting workshop with leading academics, Florian Ederer, Justus Haukapp, Tom Wallman, Carmine Ormaghi, but also practitioners from the FTC and from the private sector on the 10th of April. So if you're interested in this topic, please register. We'll try to use the same format. We're learning also in the format. It's the first time we use this format, and I hope that it works for all of you, or for many that perhaps can make it on the 10th of April. Now, thanks again to everybody, and hope to see you soon.